The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
Hi everyone, welcome to another edition of Eye on Oshkosh. I'm Cheryl Hentz along with my guest co-host, Miles Maguire from the Oshkosh News Network, Oshkosh Community News Network, and Oshblog. Tony is on vacation as we tape this show, and so we're very happy to welcome back Miles to the guest host chair. Also joining us in this edition is Professor Emerita Ann Frish with the University of Wisconsin-Oshkosh. When she was teaching prior to retiring just a few months ago, she taught human services. But on this particular show, Ann is here to talk about her work and her role as an activist when it comes to open records, freedom of information, and that type of thing. So we're going to talk a little bit about that tonight. One of the things we're going to talk about, of course, is the Freedom of Information group, which you're involved with. And they deal with the Freedom of Information Act and things that sort of spawn from there. So why don't we first find out what the Freedom of Information group is and what it does?
Well, this is the Wisconsin Freedom of Information Coalition and Council, pardon me. And it's a statewide group devoted to protecting Wisconsin's public records. We don't deal with federal records at all. It's only devoted to dealing with Wisconsin records. And I'm a public member. The council is a group of newspaper people who've been working on this for a very long time. And they have public members, so I'm one of their public members.
How large a group is it?
I think there's 18 members, but there's so many people going and coming, so very often we have many guests, and sometimes we don't know who's a guest and who's a member.
How did you get involved in that?
Well, I've been doing public records since about 1995 as an animal rights activist.
Okay.
And one time I read in the newspaper that they were going to start changing the Wisconsin public records law, so I got very alarmed and I started finding out who were the people who were involved, and I called them up and I found the Wisconsin Public Records Council, and they said, "Oh, well, who are you and what's your interest?" So they said, "Well, we're looking for members, and particularly public members, and so send us a little vita on who you are and what you've done." So I mean, I've literally from 1995 requested hundreds of public records, state, federal, local, and it started out with the story of the Melrose Court ducks in Neenah when they were going to kill a whole bunch of ducks, and people came to me because they knew I knew something about records. It was only theoretical at that point, and they said, "What are we going to do about this?" And so we went door to door, and we acquired the records on they were mostly state records that showed that these ducks were diseased, and we looked at them. We took them to some vets, and they said, "No, this does not constitute any public health emergency." So we then read the health director's records and all the records related to complaints, and so we requested the complaints, and they denied that for a while, and then we said, "Sorry, you got to give them to us." So there were times when I was going into the mayor of Neenah's office and sitting there, and they would have a file of records, and we actually there was a court case against one of the state agencies, a federal agency, pardon me, because he had libeled somebody we were working with, and they took him to court, and the federal government said, "No, it's not part of your job to libel people or slander people," and he was removed from his job, or he agreed to step down from his job in doing all the egregious things that these people thought he was doing, rather than have to defend himself on his own dime.
Boy, and doing that for the last 10 or 11 years or so, I'm sure you've got a lot of stories that you could
Oh,
share.
yeah.
And we're going to talk about the five rivers, because I was involved with some requests there earlier this year. So we'll talk about that a little bit later. But I think a lot of people don't necessarily understand A, what information's available to them, and B, what isn't. How would you, in a layman's term, define the difference between what is and isn't available?
Okay, and for the moment I want to broaden the scope to public meetings and public records, because they're very much intertwined. There are records that are brought to meetings, and so it's both of these issues.
Sure. And open meetings tie in with this too, right?
Yes,
So we'll talk a little bit about that
two
too.
separate things, two different parts of the statutes, but still very much interrelated. Well, I thought I would just start by talking about the policy, the declaration of policy and the statutes. And to quote both on the meeting side and the record side, because I think what people should assume when they're interested in what's going on with government is that everything is wide open. Now it's not, and there's some legitimate reasons and there's some legitimate things that aren't open to the public. And it's really much too complicated to get into in any sort of detail. But I think people should start with a presumption that belong to us.
We pay for it.
We pay for it. There are records, and with some exceptions. And if you listen to the words of the statute, this is the meetings law. In recognition of the fact that a representative government of the American type is dependent on an informed electorate, it is declared to be the policy of the state that the public is entitled to the fullest and most complete information regarding the affairs of government as is compatible with the conduct of government business. So if there is something that interferes with business, it might be an exception, but Section 4 says the subchapter shall be liberally construed to achieve the purposes set forth in this section. And then there's some information on penal statutes. The doors of each house shall remain open except when the public welfare requires secrecy. So it's a very liberal interpretation. The idea is meetings are open to the public. And the same is true with records. Providing persons with information on the affairs of government is an essential function of representative government, an integral part of the routine duties of officers and employees whose responsibility it is to provide information. To that end, the statute shall be construed in every instance with a presumption of complete public access consistent with the conduct of governmental business. So, and then of course, under the records law, there are my employee records as a state employee, and then there are other records that people have that get into the government records. And as a person who is a subject of the records, I have the right to see those. Even if somebody else doesn't, I have the right to see them. So it's we have one of the best public records laws in the country. Not the best, but very good. I'm very concerned right now that people are chipping away at our access to records as well as meetings.
Well, in general, aside from that sort of personnel exclusion, what are some of the other things that are outside of the bounds that people
Are we
can't
talking
get
about
at?
meetings?
Meetings,
There's a
records,
whole set of exemptions in the meetings laws that get applied to public records. But just because it's excluded in a meeting doesn't mean you can't go back and get it after a decision has been made. Well, one of the major exceptions is anything social or medical that relates to me as an employee would be an exemption or probably easily exempted. The idea is that the public interest in releasing the records outweighs the public interest in protecting people's identity. So you might get a situation where a police officer has been abusive to people. I say the public interest in knowing who those people are and what they're doing and are they being appropriately reprimanded or fired if necessary outweighs the public interest in protecting their identities. So there are some exceptions for informants. people who might be harmed by seeing their own records, for example, the medical records. Then there's another key exemption that has been relevant in the Meetings Act recently, and that is on the conduct of business. If there's negotiating or competitive bargaining going on, then the entity can claim that there's an interest in having a closed meeting, and by inference closing the records to it.
And that brings me to another question then about closed meetings or executive sessions. You know, it's always been my understanding, Ann, that those records, once the subject matter of the meeting has come to fruition, if you will, those records then have to be released to the public. Is that correct? And then the second point is the problem that I see with the records that they keep is, at least in Oshkosh, within city government, they're not really keeping minutes of those meetings. And so it's very hard to know exactly what went on in those meetings.
I was involved in some closed meetings in our search for a new dean at the university, at the College of Education and Human Services, and we kept no notes of that meeting. Then when we went into open session, then of course, under some circumstances the individual votes are recorded, and sometimes just the total votes are recorded. But there are still records that were used in the meeting. Actually, we had our own records. Now, whether or not they're recoverable or not, I suspect that would be a real challenge. So my own personal notes, I went and read all the files, and then I made my own personal notes. I think in that case, those records were just shredded so that nobody would get them in any case.
So once it's reached a resolution, then someone can request those closed meeting records or minutes if there are some.
Yeah, and in other cases, there are records like studies that are done and that haven't been released. I suspect a lot of union bargaining, when they make their strategy and those meetings are closed, but once the decision is made and the contracts are signed, then there's no need for any secrecy in the records, many of those. But I think the presumption always is they're open, unless somebody can reasonably argue that the public interest in keeping them protected outweighs the public interest in releasing the records. And that's where the difficulty comes in, but it is a balancing test. So essentially, I guess every case is a new case.
Sure.
You have to weigh the interest in releasing as opposed to the interest in withholding the records.
Well, earlier this year, you had filed an open records request on things related to the now defunct Five Rivers project. And you had gotten some other folks involved in that. Tony Palmieri and I were two of the other people involved in that. And, we ran into some snags along the way. And since you were sort of the go-to person on that, I'll let you explain to the audience and to Miles what some of those snags were. But I think by and large, we found City Hall to be pretty cooperative.
Oh, yeah.
And very helpful. But there are those roadblocks where, things are left very open to interpretation. And there's where we ran into roadblocks. So why don't you share with folks what we ran into?
Well, there were two principal reasons they wanted to withhold some records. We had asked for the records of their conversations and documents with their consultants, the financial consultants and the attorney consultants. Now, attorney records that's privileged. So almost anything that if attorney says something to the council, that could be withheld. And I'm not sure how you get around that, but the problem is that sometimes the attorney handles everything that they want to keep secret rather than things that are legitimately attorney related. But still, with an attorney consultant and a financial consultant, we're the people who have to make decision on, do we want this? We have to give guidance to our council members, don't do this, or that's too much, or whatever. So I thought it was fair enough that we should get the financial consultant's assessment of Five Rivers Corporation. The other thing they withheld from us was some kind of things that Mr. Doig didn't want released, supposedly some kind of marketing study. And I'm not sure how that was relevant to the debate or why it should not be released, but we did not get that.
Now that this project is history, could those things all be asked for again and
Oh, yeah.
now received?
I think so. I'm not sure what would happen in the case of Doig's famous marketing study, but yeah, essentially that issue is still open because you filed a complaint on the closed meeting.
Yes.
And then we requested the records. And in the case of the records, the state Attorney General's office, that's you can go to two places if you want to get some help in getting some records, and one of them is the local district attorney. District attorney can order that they be released. In this case, the district attorney had some conflict of interest and he didn't want to deal with the closed meetings, presumably didn't want to deal with the records either. So we went to the Attorney General. The Attorney General said, well, we've already talked to the city, so we can't represent you. And so he sent it back to the district attorney, who was supposed to appoint another district attorney to intervene for us, and then the project got dumped. So we didn't pursue it, but theoretically we could go back and say, who is the person you appointed, and file to make them give us those records.
Right.
So it might be instructive in knowing what were their considerations, because, and I can't help but think the request for records and the challenge on the closed meeting all started sort of precipitating some doubts. I think especially the challenge to the closed meeting. And then people were saying, like, so what's the big deal? You know, why do you want to close this meeting? What are you talking about? What's so secret from the people who have to pay the bill?
Sure. And I should just give folks and you both an update on that too. It seems like it's taking forever for this investigation. And I did talk with one of the Attorney General assistants in the Public Integrity Unit about, I want to say about 3 weeks or so ago, and he said they only have like 7 investigators to cover every complaint that they get from the entire state. Well, that's, you know, a voluminous task in and of itself, because they get thousands and thousands of complaints. But he assured me that they are continuing, and the reason that the council members haven't been contacted by them is because he's not going to go to them. They're the ones being investigated. So he's going in other directions with his investigation. So he's assured me, though, that, you know, it's still being pursued and it's being taken seriously.
So they're actually doing something with it, not just letting it
Yes.
sit in a pile.
Yes. And, you know, we went directly to them and filed, as opposed to the Northwestern, which filed with the DA's office. They did some legwork, and then the DA's office, because of the conflict that came up, had to turn it over to the Attorney General's office. So they're both sitting there now. But
This is probably going to get dealt with in the Wisconsin Court of Appeals, because the town of Milton had a separate, another issue. They had closed meetings on an ethanol plant, and finally approved the ethanol plant, and then they announced it to people after it was a done deal. So no involvement of the public at all. In fact, they thought it was something about an industrial park. So they didn't even tell people what we're considering approving an ethanol plant, which is really, you know, pretty brash
right.
for a city council to do.
Well, you know, even some of the things in the law, some of the presumptions in the law, I think, if you think about them logically, don't necessarily hold up. I mean, the idea that some background here, I used to work for state government in Maryland, and we worked, and it was the Maryland Port Administration, ran the Port of Baltimore. And so we were negotiating with steamship lines and shippers and all that, and we were covered by different law, but a similar exemption. If it was a commercial, pre-decisional matter, then we didn't have to reveal anything to the public, and we didn't. But it was mostly because we didn't want to. It wasn't that there was anything of value, and in fact, we might have served the public better if we had said to the steamship lines, well, we can't give you that you want that because the public will never stand for that. we can only go this far and not that much further. And I think the same thing you could argue with Five Rivers. If you're negotiating with a developer behind closed doors, he actually has more leverage than if you say to him, no, we're going to have to tell people about this, and we can only do what we can do. So it's kind of a
what you
backwards sort of
present to
thing.
the council is now, of interest to the public.
Sure.
So,
And some folks out there at this stage of the game may say, well, the project is dead, so what's the point of pursuing anything? And from my own standpoint, I want to see the original complaint, which was filed back in early March, come to fruition. And because I think that they have made some mistakes, they being the council, and if they have, they should be called on it.
I agree with
and
you.
so that it doesn't happen again.
Absolutely.
And not only
That's
that, I
the
mean,
reason.
that land is going to be developed.
Exactly.
So this
Yeah.
we're going to go down this road again.
Right.
So
And same thing like with getting the rest of the records. I think if you can actually see all the records in toto, then you are able to take a look at future decisions that the council may make and say,
right.
okay, this is why they're making this decision, or, this is why they're making a decision, but we don't think it's a good decision.
One of the records that we did get were records of how much the city paid to various attorney firms and financial consultants. And that was quite a bit. I don't remember the exact amount.
It was substantial.
But that's a very definite, is this worth this kind of money? Now, on the one hand, if the city's going to benefit from tax revenues and so forth, you want to make sure you make a good decision. You don't want to just take the developer's word for this. You want really good expert opinion, but that's a subject of discussion. How much is it worth? Do we want to pay this? It's not free. It's not just like, come and bring your plan and we'll say yes or no.
Right.
Well, it seems to be another thing that should be challenged, although I don't think it would be successfully, is this notion that the attorney communications are privileged. I mean, because we are the client. So I can understand
right.
the attorney-client privilege in some contexts, but we're the client, so why can't you tell us what you're advising us to do?
Right.
That's nuts.
Yeah. In June, shifting gears here a little bit, in June the State Ethics Board rolled out its Eye on Financial Relationships website, and that's a site designed to give voters some information and knowledge of the financial relationships between those running for office, whether it's a new office that they're seeking or re-election, and those who are contributing to their campaigns and so forth. And it's all part of an effort, I guess, to make government and its officials more open and in the end, I suppose, help with some kind of campaign finance reform. But there's a drawback to that, and that's an age-old law that basically, if you want to look at a public official's file, which includes investments, commercial clients, and other sources of income, before you get to look at anything, the ethics board, you have to provide a name and an address to the ethics board, and the ethics board then in turn provides that information to the very public official or candidate that you're making the inquiry about.
And I think that violates the public records law, because the public record law says a requester is anyone who requests a record. So you can go in and request a record and say, I'm Jane Doe. I'll come and pick up the file on Thursday. So I shouldn't have to give my name. It shouldn't be something that could be retribution. However, there's an easy solution to go around that, and then the Freedom of Information Council has discussed this. The Freedom of Information Council would request all the records on an ongoing basis, sign the president's name, and then just make it available on a website somewhere.
Are they going to do that?
I don't know what happened to that. We did have a discussion about it. I think they're just trying to get the law changed because it's patently an attempt to put pressure on people not to request that information. And it belongs to, we have an interest in knowing who our legislators are being influenced by.
Sure.
In a very substantial kind of way.
Well, I conducted a very unscientific poll on Eye on Oshkosh about whether or not that law should be revealed, and only about 70-some people took part in the poll, but 65.22% said that law should probably be repealed, and 34.78% said Yeah, it's a reasonable law. I don't see myself under any circumstance why that is a reasonable law. I can see where it would actually deter people from filing for requests for information.
That's the point.
Yeah.
Yeah, I mean, why do these public officials need to know who is making an inquiry about them,
Yeah.
if not for some kind of retribution?
Well, that might be a good question for some of our Assembly and Senate candidates to get them
We're going to
on
be
board on
interviewing
that.
one on our next show. So.
Good question for them.
Go ahead, Miles.
I was just thinking that there are more than just elected officials who are covered by that law.
Yeah, right.
So I think that in Oshkosh there are about 24 people. The obvious people who are in the Assembly or the Senate, but people like the Chancellor and other high-ranking state officials. And maybe one solution is, what I think people are mostly interested in are the legislative folks and what kind of financial activities they're involved in. So maybe a solution would be to cut it in half and say, there are some people who are on boards and commissions that it's almost a public service that they're serving on this board and commission, and whether we need to know everything about their financial records. Maybe not, I don't know, but it would seem to me that clearly that members of the legislature should make this stuff available.
Sure. And I realize that we kind of left Five Rivers rather quickly. Was there anything else about Five Rivers that you wanted to talk about, problems that we ran into, things
Yeah.
that we found?
Well, one of the problems that I think this is, and we started mentioning it before, the fact that when the city got our request, they called the state attorney general's office to get some guidelines on how they were should handle it. And then, so now the state can't handle our case, can't represent us, because they've been sort of representing the city. Now, the fact that they asked a question, I don't think that shouldn't nullify our right to be represented by them. Now, they did provide us an alternative solution, but they should have just taken it on, I think. Because otherwise, every time a public agency gets a request, they call the Attorney General's
Right.
office, and then they're off the case.
Sure, that stops the process.
Right.
Yeah.
So there's got to be something wrong with that. Now, we did ask for all the records related to that. We wanted their notes and their memorandum and so forth, and they said there were none. And then we asked their phone records because we wanted to check the billing records. And yes, we did get the billing records, and we did see the city's call to the state and so forth. But nobody kept any memos, which I think was really interesting.
Well, yeah, and here we are paying attorneys, who are acting as consultants, if you will, on this project. And then when it comes down to handling an open records request, they all of a sudden have to run to the state attorney general's office. And it's almost, I'm not saying that this is what happened, but it certainly gives the impression that they were trying to shut down the process almost before it got started. And nonetheless, we did get a fair amount of records, and I think that we helped to raise people's curiosity and ire a little bit, if you will, about just what was going on and how in the dark they were really trying to keep us.
Well, I would very much like to know what the Attorney General of the state, whatever attorney handled it, told the city. But the assistant attorney told me she didn't keep any records either. And it was only about the process. So how does that substantively mean this record gets denied and this record gets released? So, no records.
And if it's only about the process, how is that providing them with legal advice?
Oh, right.
So I don't know, it's kind of weird. So what is Ann Frisch's next step with respect to Five Rivers?
Well, I think we should talk about what records we still want to get. And,
So this is not a dead issue,
I don't think so.
even though
I
the
think
project is dead.
and we're glad about that. Whatever little piece we contributed to that, fine. On the other hand, I think we all care about the development of the city. And just because they did the records wrong doesn't mean it couldn't or wouldn't have been a good project. So I hope that the next good project that comes up, and this might have been one, who knows, that everything is full disclosure. And if people want to bring their development thing, we tell them everything is public record. No little secret conversations like the deals with Doig and some of the council members. You have to sign here, I'll talk to you, but you have to sign off. We're not going to have any of that. Everything is open to the public because they're the guys we represent. And I just hope that people, when city councils, like in Milton or Oshkosh or whatever, if council members are going to vote to close meetings, I hope we get rid of them. Because that's our choice. But we shouldn't have to do recalls and new elections just to get open meetings and public records.
Well, no, and especially when recalls are such a mammoth task. I
Well,
mean,
they
it
are.
really is, from start to finish. And in this particular case, too, yes, all these fees that we paid for consultants, in the long run, they paid off. But I think we could have reached the same conclusion
Right.
without the consultants. We were saying all along, certain things about this just didn't make sense. And yet they needed a consultant at tens of thousands of dollars to tell them what we were saying.
Do you have a sense, I guess either one of you, of whether this council does this kind of thing inordinately? I mean, if you look at the agendas, there are, from time to time, there are executive sessions, personnel related, or land acquisition in some of the industrial parks and things like that. I mean, do we just not pay attention to those things because they seem to be routine, or should we pay more attention to them, do you think?
Well, citizens should be paying attention to it. I think the council should, perhaps be more educated on public records and meetings. I don't know how much they do it. I suspect not a lot. But if you do it on a big critical issue of lots of money, that can override a lot of things. So I think they should be challenged on every issue that they think is a closed meeting or not releasable record. But again, it takes a lot of effort, and you have to know that you can appeal, and I think we're entitled to get some help from the Attorney General on this. I don't think it should
Absolutely.
be to everybody pointing the finger like, well, go to him.
Well, they basically make you jump through 101 hoops and take part in a dog and pony show, in order to get records that we've all paid for in one form or another, and that we're entitled to.
And to excuse yourself on the grounds that we don't have enough staff is just not acceptable. When I was getting records from U.S. Fish and Wildlife Service, Animal Damage Control, as it used to be called, they had offices in Washington when they had boxes and boxes of these records. And one of my records requests literally took 2 years, and they would always say, we just don't have enough staff. Well, put the money in the records, or stop making stupid decisions and programs, and we'll lay off on the records requests.
And that brings me to another question, Ann. Is there a time frame with which a governmental body has to respond and comply with your
And
request?
Wisconsin law says as reasonable, practicable, and without delay. So that gets translated into 10 working days.
But that's just an acknowledgement of your request. It's not a fulfillment of the request.
No. That's the record. You're supposed to have the record.
10 days?
Now, it used to be 10 days federal, but now it's 20 days. But, sometimes even that's too much time. And if you can do it, it sort of becomes a minimum rather than a maximum. That if you have 20 days, you wait 20 days. So 10 days should be reasonable, and you can go to court in 10 days if they haven't provided it. So it's not like they can just acknowledge it. However, in some cases, they do acknowledge your request in 10 days, and that's all they've done, is to acknowledge it and say, it's going to cost too much, and here are some of the problems in providing these records. And I always, when I make a records request, I always give a maximum amount I'll pay without any further authorization, because some of those records, some of the way that agencies are getting around providing records is to say it's going to cost you $6,000 for these records. And when you write public records, you should always make them reasonable, and you are required by law to make it identifiable. You can't just say, I want all your records from 2005. You have to be reasonably specific and limited, and so I try to do that. And some of my biggest mistakes have been not being specific enough and limited enough.
Now, as far as a cost, that's only if you want copies of the records, right?
That's right. When we went in to get the records, we took our little portable
Yeah.
copier, and the rule is that if the cost is over $50, and they can charge you on some search fees, but if it goes over $50, then they can charge you, but if it's under $50, they can't charge you anything. So I always try to make my requests, Wisconsin requests, say, please let me know if it's going to cost more than $30 or $5 or something. So then they have to tell you, and then if they say your request is too unreasonably large, then you say, okay, let me cut it down this way and this way. So for example, on the Five Rivers records, we asked for the emails. Now ultimately we did get them because they were all printed out, or we think they were all printed out.
Yes.
Okay, that's the thing we don't know. But if you go and look at all the emails, they already put them in some kind of storage. To get them out of storage then costs some money. And then, we don't want people just making records requests just to keep agencies in a state of chaos all the time. So, to some extent, there's some justification for getting the charges. On the other hand, when we want to know what they're doing, we have a right to know.
There's a way to avoid all of that. Just keep the
Just-
stuff open and
I know it.
you avoid everything.
I have a friend who works for the city of Budapest. Old communist nation, secrecy, terrible things going on. All their records are on the internet. That's what I'm told. I can't read them myself.
So you did get the Five Rivers emails?
We agreed to limit it to not that because we didn't want to get into big money.
I see.
And it sounded like, and they were being pretty reasonable about it. First we would look at their files, their paper files. And if we found something we found curious or something we want to know more about, we'd say, I got to see the emails. But we never felt that way. We always found lots of printed out versions of the emails.
Now, is there anything in the law that sort of reflects newer technology where you could say, I don't need printouts of the emails, you can just send them to me in an HTML format and I'll review them there? Is there a way to do that?
There's no reason why they can't just forward you a copy of the email. The thing that, and often you can just say, can you send me a copy of that? You don't have to go to a public records request to do this. So, for instance, when we were working on the Diebold issue, trying to stop the Diebold touchscreen machines, I asked the clerk, can you just send me copies of the things you're sending out to the council members? She said, sure. So every time the council members got something, I got a copy of it. However, I don't know for sure if I got everything.
Right.
The only way to find out is to go back and look at their files, look at their email. I've gone in and looked at people's laptops where they had all the files. And you can go through them all, read them all, theoretically without any cost. But in one instance, I requested some records and I didn't put in the caveat about how much I would pay without further authorization. And they charged me $80 or $90 because they had brought a whole room full of stuff. And they knew darn well if they had said to me, this is a lot of stuff, you're asking for lots of materials, we have a room full of it, do you really want all this stuff? I would have said, well, I want this and I want this and I want this. But they thought they could get me, and they did.
Who was this?
DNR.
DNR. Okay.
In the case of the city, though, again, I think that by and large, as I said, they tried to be very cooperative.
Oh, yeah.
I think they were a little surprised by the portable copier. It's not everyone who does that, but here comes Ann with her little portable copier.
And I also done it differently. I helped a family access their own records in a child abuse case. And we took my laptop, a little portable scanner, and the father sat there and said, I want this record, unstaple it, slip it through the scanner, it pops on the file, and then we ran copies of it. So, there are lots of ways to do this without incurring the photocopy charge, especially because in Wisconsin you can charge up to 25 cents per sheet for a photocopy. And they still try to charge more, by the way, sometimes. There are some records that by statute cost $1.50 a page. We got to get rid of that. Just absolutely. Another thing is, it takes energy and time to handle these records. So, as I said before, we don't want our agencies destroyed because people are just playing
Sure.
games with them and making work for them and that sort of thing. We don't want that.
Right.
So, someone has a legitimate reason in their mind for filing an open records request. It doesn't have to be an official open records request form. They can just simply make the
Right.
request by email
Right.
or...
So first of all, you can just ask, could you just send me a copy of that? Or can I come in and take a look at that? And, you know, many times they'll just say, sure. When I worked at the university and I was curious about something, I just email whoever the department chair was and said, could you send me a copy of that? And by return my email, I mean, no big deal. But the records process is a formal process designed to make sure, and then there are eyes on this, to make sure that you get what you ask for. So it has special handling, and so, you know, but however, people don't have to tell what their purpose is. So when I teach my students how to use public records law, I give them an answer to that. When they say, what do you want this for? The answer is, oh, I'm just curious. I'm interested. Well, I'd like to see what's in the files. Because that's all the justification you need is like, I'm curious. I want to know what your agency is doing about such and such. I want to know what your correspondence is. So just to say, I'm just looking, is a good enough reason. In fact, you don't have to give a reason. You just say, I don't have to give a reason. But to me, that's a little confrontational, so I decided to say, well, I'm just looking.
And refresh our memory again, you do not have to give your real name?
No, you
Okay.
can just say, I'm a requester and I'm requesting. You can do this. And by the way, records requests should be written because if you get turned down, then you can't appeal something that's not on paper. Okay, so you need to leave a record. But if you ask somebody, can I have a copy of your whatever, and they say no, then you go ahead and put it on paper.
Okay. And you have to be specific about what it is that you want.
What it is you want,
And the time
time
frame?
frame. I usually say from January 1 to the present time, or maybe I want older records, like it could be from 2001 to 2002. So on the one hand, you really want to do a little exploration because you don't know what's there. So you want to be broad enough to get stuff that you might not have thought to ask for. On the other hand, if you ask for too much, they'll just charge you way too much.
And put a dollar limit on in your
Always
request.
put a dollar limit on.
Okay. And the thing is, just because you put a dollar limit out there does not mean either that is what they're going to charge you. I mean, you had put a dollar limit out there, and had we not run out of time that day, we could have copied all the records that we wanted for free. But we did run out of time, and so we just had the city run them off, and they did charge us for that. I don't remember what it was offhand, but it was around $20, I think. It wasn't too terribly bad. So it's not like they're going to necessarily gouge you either.
No, well, they can't charge more than 25 cents a sheet.
Anything else that folks need to know in making an open records request?
Well, first of all, they should just do it. Put it on paper. I think it helps to say pursuant to Wisconsin statutes or something like that. You don't have to give the statute number. You could say, according to Wisconsin statutes, I'm entitled to have a copy of your correspondence with so-and-so.
Okay.
And it should be on paper, but you can sign it, requester, I will pick this up on, you can call this number when you're ready, although if people want to be anonymous, that's a little, I'll stop by and I'll find out when this is ready.
Okay.
And by the way, this goes for police records too. A lot of police records are open to the public. There are a few that are not, like their rap sheets are not. Things that are subject under investigation. Some things might be open, some things might. The one thing that police have to give, according to some case law, is if they've arrested somebody. We theoretically have no secret arrests in this country. Of course, we know that now we do, but if somebody's arrested in Oshkosh, they should reveal that on the day it's being requested.
But that typically is not done.
Well, I know, and even the Northwestern has complained about that.
Right.
So I think it's something to deal with. Peggy Davidson from Journalism Department and I did a study which we're getting ready to publish, but we found very few police departments that actually provided the records on the day they were requested.
Yeah, I mean, that's kind of funny. The police are supposed to enforce the law, and yet
Right.
every day they're breaking the law. It doesn't
Right.
really, lead to a sense of good order in the community, does it?
Do you have a feeling of why that is? I mean, is that, obviously it's something that's pretty customary with police departments.
I think the reason is there are some things they can withhold and must withhold, and then some things that they must release, and then there's some things that they can if they, can justify it. Okay, so I think it's just so much easier just to say no.
Yeah. Yeah. The other factor, and I think Stu Rickman wrote a column about this a couple of weeks ago, that it's so much easier to deal with the county than the city because the sheriff, the Winnebago County Sheriff, is an elected official, and so he has to sort of court public opinion, whereas the chief of police in the city is appointed and he's sort of protected under several layers. And because you would think that it is something that annoys the Northwestern, and they know it, and they've made it clear to the police department that they want this information and they can't get it. So, but there just doesn't seem to be either the leverage or the mechanism to pry it loose.
Well, and I'm not sure what it is about the Oshkosh Police Department, but I had posted something on your particular site probably a month or so ago when the Winnebago County Buyer's Guide, I believe, was having some problems getting police report information. I've never seen a police department like Oshkosh where they just give you a sheet of all the calls, and as a journalist, if you want to find out about a specific call, you have to give them the report number or the case number, and then they have someone who tells you about it. You don't have anything that you can actually look at. Every other police department I've ever dealt with as a reporter, they just give you the printout of everything and you just go through, and then if you want more information about it, you can ask. But usually, I mean, unless it's a homicide or something along those lines, everything is right there and you don't need any more explanation. I'm not sure why they're not as forthcoming with information.
Yeah, I don't know. I mean, even, one of the favorite parts of the student newspaper at the university is the busted column, where every week the university police provides information, the name of the individuals, the stupid activities they were involved in, what they got caught doing, and, it's just right there. So I don't know why the city. I mean, it is from as a journalism professor, I tell my students, oh, this is information that under the law you should get, and then I send them down to the police department, and they come back and they say, well, I didn't get that. What's going on?
I think part of what's happened, they used to keep a police blotter and would have all this stuff on it. So you can go down and look at the blotter if you're a journalist and copy things down. Now it's all coded on a computer. So rather than having name, address, and so forth, they have incident number. And then you can't figure out what you have to say. Well, when you look at it, it says incident and a number, and then it has the badge number and so forth, and then it'll say drunken driving or something like that. So you don't know who's who or what to say, I want this or not that. So it really would be helpful to know. And these are public actions that they're accountable for. Who, if it says Ann Frish, living on a certain place, charged with something, it should be available to the public. And I think, people get very touchy about this because people say, well, I don't want people to know about that, but excuse me, this was a public offense. And if you're found not guilty, then you want people to know you're not guilty. So some of these computer sites with court decisions on them, people also get very touchy about, because I don't want that up there that I was being or whatever. No, you want it up there, and then it said not guilty.
Moving on to something in our remaining moments here. Earlier, you had mentioned the Diebold machines, the electronic or the touchscreen voting machines that earlier this year the county had voted to accept some grant money. The county board had voted to accept some grant money so that the various municipalities can purchase one screen per polling place, I think is what they ended up approving. And you were very much opposed to these screens, as a lot of people were. Tell us what you did in that regard to try and stop this.
Okay, and to bring it back to public records, your ballot is a public record. It doesn't have your name on it, but it's a certified ballot. Okay, so it should be something that people can look at. And now with the Diebold touchscreen machines, you have a tape that has sort of a mini version of what the machine thought you voted for. And so how could you ever duplicate that for anybody who wanted to know? You can duplicate, I'm not sure they actually do this very often, but you can actually see this record of my handwriting, and I actually voted for this person or that person. So that's how we bring it back to the public records issue. Well, there was something in the newspaper that morning that they started discussing this. Some of us got together on email and said, whoa, this doesn't look good. We thought somehow we were exempt from Diebold touchscreen machines, that we would escape, that it was out there, but not in my backyard. And so some of us got together and we said, this doesn't sound good. So we literally had to start educating ourselves on the Diebold touchscreen machines. And it's not just Diebold, it's all the touchscreen machines. So we had some conversations and we decided we were going to oppose it, and we had some reasons why. We had done some research. We went to we were there that evening when they first started discussing it. Then we went to the public hearing, which really was not a public hearing because you couldn't just ask questions of officials. So this presentation, you could make your statement and then somebody else would make a statement. Mr. Kennedy from the State Elections Board made a statement, but we couldn't ask him questions. Council members or the supervisors did, but public couldn't. And regular public hearing, you get to talk. And we did a lot of lobbying with the board members, and there were a lot of people. In fact, all the people who testified, I would say maybe with one or two exceptions, were opposed to the touchscreen machines. And the people who were in favor of it were the people who were worried about, are we going to comply with this law, and what's going to be the consequence, and they're all the government insiders. So I thought that was really a fascinating dichotomy. But most of the people, they just came out of the woodwork, and I didn't know the people. They just heard about the issue and they said, we don't want them.
Well, and we're going to end up getting them.
We're going to get them. We just lacked 3 votes of getting it turned down.
Yeah. I guess if there is an upside to it, there will only be the one machine at each polling place, at least for now, and you're not required to use it. You can still use the other machines, and I just think that that's the route I'll go. There's something about dialing, writing in that little oval there that I like.
It's really too bad more people aren't going to get a chance to try it when you don't have to throw away your vote. Because, for example, this is the first time in my life I've been disabled, because when I use the touchscreen machine and I have bifocals, to read the little printout on the tape of who I think I voted for, I have to get down like this. And if you fold over the magnifying glass, that doesn't do a thing for me. So I literally would have to have somebody come over and say, well, I voted for so-and-so and so-and-so. Is that who's recorded on the thing? So I'm now a disabled person for the purposes.
Now, a minute ago, you said that the voting records were a public record. But
well, I'm just saying that they're inspectable.
But not in the sense that I could find out who you voted for.
No, because there's nothing
right.
on the ballot that says Ann Frish voted this way.
But so, what can I look for? Can I look at the ballots? Is that?
I don't know what the procedure is. It's but people do. I mean, the political parties go down and they say you have a stack of ballots, and I've never actually been involved in this process, but they can look and say, what do you think? Is this right here, or hanging chad there, or something like that? And you can say, no, I think it's very clear that the voter intended to vote for such and such, and we need to record it that way.
So in the event of a recount, and I know we did a show on the touchscreen voting machines. It was a while back, though, and I don't recall. But having been very involved in this, I'm sure that you can answer the question. In the event of a recount, what will they be recounting? What will they see?
Well, they'll be recounting what the machine said you voted for.
And that'll
Okay.
be this little tape,
It's a
almost like
tape.
an adding machine type
Yeah, I
tape?
think so. And then it goes into a sealed box. But if you could just imagine rolling this out like on a table, and then is everybody going to get down like this? 'Cause that's the way I'd have to get down with my bifocals. See, that's what it says. You can't. You know, it just boggles my mind. And then when I called some board supervisors, I said, how are you going to do this count, you know, if we have a recount? And they said, well, somebody will figure it out. Almost everybody said, well, somebody will figure it out. And I'm saying, like, you're the people who are supposed to know this.
Right.
So I'm very concerned about that. And I would also bet that 50% of people will never even look, not even look, even though they would if they had this big sheet of paper and it says, you know, yep, got it, that's right. But how many people are going to read that little thing, given the problems I have and the fact that it's so small? We don't look at our time receipts anyway when you go to the time machine. I know because they're on the floor. And I know people just let them drop out and go, assuming, of course, that the bank has, you know, got everything, hasn't made any mistakes and so forth. So I think it's just, it's a science fiction nightmare.
Well, and they have had problems in a lot of different states where they've been used already, and you know, we shouldn't just assassinate the debold machines, as you said earlier.
It's all the
touchscreen
Well,
machines.
some people are concerned because one of the machines is owned by the government of Venezuela. Now, I'm very fond of the government of Venezuela, but other people are not. And so that has alarmed some people, but why should a foreign government, any foreign government, own our,
Right.
own our
Absolutely.
ballots?
Yeah, that's crazy.
And that's the problem, because those ballots then are the sort of private property of the companies. Now, I'm not sure. I suppose this time roll will be sealed somewhere. But you just think of the logistical problems. Where are these machines going to be housed? In a school? Who has the key? The janitor? You mean nobody has the key? The election official has the key? Of course, in the Busby-Bilbray elections in California, 50th district, the machines all had a sleepover and were in people's garages and cars and before the election. Apparently, that's a fairly common practice. But the machines arrived, no seal on the not tamper-proof. You know,
That's crazy.
it's a nightmare.
Very quickly, Ann, in just a few seconds here, where can people find out more information about open records requests?
The FOIC.org is the Freedom of Information Council's website, and they have sample, and well, you know, you can contact us. We don't formally have a assistance service, although we've talked about it. We really need a statewide organization to just do sort of a 800 number.
Okay.
How can I write this number? But people can call me if they want to.
Okay. All right, very good. Thanks so much for being here. It's been
Thank you.
fascinating and a fast
Fun to be
hour.
here.
Thanks, Miles, and thanks as always to you for letting us in your home for the last hour. We'll see you next time. Until then, take good care. Keep your eye on us. We've got our eye on Oshkosh.
Thank you.